Thank you very much, and good afternoon, everyone. Welcome to the April 8th joint committee meetings between the Public Safety and the Planning, Housing, and Economic Development Committees. We're going to be discussing one topic, or a continuation of a discussion on one topic, Bill 4920, which is Human Rights and Civil Liberties, Discrimination in Rental Housing, Fair Criminal History, and Credit Screening. It's also been called the Housing Justice Act. The bill aims to reduce bias against homeless and justice-involved individuals in the rental housing market by ensuring clarity and transparency of rental application requirements and prohibiting inquiry into or making housing decisions based upon low-level, quote-unquote, survival crimes. I'm pleased to serve as a lead sponsor along with Councilmember Glass on this, and I thank him and council staff and the many public and private stakeholders who have helped get us to this point in this process. I'm going to turn it over to co-chair Councilmember Reamer, and then we're going to turn it over to Councilmember Glass to make their opening comments. Then we're going to invite Ms. Christine Wellens to quickly walk us through the packet summarizing the background, public hearing, and first work session before taking us into the three issues for our consideration today. I think it should be noted that Councilmember Reamer thought this would be very fast, so we'll see how well he can predict these types of things. Councilmember Reamer, President Reamer, Committee Chair Reamer, please.
Well, that wasn't fair. When I said this might be fast, it was off the record.
Oh, all right. Now, okay, we'll say it's off the record still. That's fine.
Now my batting average is going to take a hit.
Yeah.
Thank you, Mr. Co-Chair. I don't have any, extensive comments. I think this is important legislation. There's a few details that are important today that we'll hopefully resolve. And I do hope we have DHCA because there are some, questions about the kind of housing that these things apply to, and we'll need someone who understands the housing in the county to be with us just to, walk through things. But appreciate the legislation, and I look forward to moving forward.
Thank you very much. Councilmember Glass.
Well, thank you, Mr. Chair. And I think I gave some opening comments at the first work session, so I won't go into everything I said, but I'll, set the tone a little bit in just reminding people that the point of this legislation is to ensure that people who were formerly homeless and formerly incarcerated are able to live in our community, that they're able to find housing so they do not have to become homeless or become homeless once again. And when we look at who is actually homeless here in Montgomery County, we have to look really hard to see, or let me rephrase that. It doesn't take us very hard to see that 83% of homeless families in Montgomery County are Black families with children, and that 64% of the individuals experiencing homelessness are Black residents. And this is a social justice and racial equity issue. And, the last thing I'll say is that it really is about fairness for people. If we do not want people to be homeless and we want it to be brief, rare, and non-recurring, we have to provide the support systems and, in certain cases, legal framework to ensure that happens. And that's what this conversation is all about.
Thank you. I couldn't take myself off mute. And before we ask Ms. Wellens to lead us through the packet, do any other council members have any other statements? No? Okay. Well, keeping in mind what Councilmember Reamer said, we're going to move right along. Ms. Wellens, please, if you could lead us through the packet.
Hi, good afternoon. Thank you, Mr. Chair. Thank you, council members. So we have with us, for this purposes of this discussion, some representatives from the executive branch, including Ms. McCrae Moody, Mr. Stowe, Director Stowe, and also Ms. Amanda Harris to answer your questions. I'll provide a brief summary of the first work session and then launch into the issues. At the first work session, you'll recall there was some robust discussion regarding two main issues. One was whether landlords under the bill should be permitted to consider the arrest records pertaining to sex crime convictions. The general rule under the bill and under other ban the box housing bills is the general rule, and also HUD guidance is that you don't consider arrest records, and the committee's discussed sex crimes records as a special case that might deserve different treatment. But the other issue at the first work session that got some discussion included whether nonprofit housing providers should be exempt in part from certain requirements of the bill. And there was also some lengthy discussion of, kind of the spelling out the process that a landlord would follow in order to comply with the bill. So turning back to the issue of the consideration of arrest records, there's a discussion for you starting on page 4 of the staff report, issue number 1. And as mentioned, the general rule under the bill is that arrest records would not be considered, that only convictions and certain types of convictions could be considered for purposes of whether or not to grant to supply housing to someone. As you'll recall from the last session, the Homeless Persons Representation Project brought our attention to some HUD guidance indicating a concern that considering a policy or practice of a landlord considering arrest records might violate fair housing laws. The committee members had asked council staff for a little more context of the relevance of the HUD guidance and the relevance of not following it. As you'll see in the staff memorandum, staff tried to address that by, indicating this, it is indeed guidance. It's not mandatory. It's kind of the best thinking of HUD's lawyers of, how it would play out in court if a policy or practice of a landlord considering arrests were to be challenged. And so, it's certainly, they didn't specifically address the issue of sex crimes. They addressed arrests in general. But I don't think there's any reason to believe that their analysis wouldn't carry over. So it's guidance. It's, part of the puzzle for you to consider. It's not absolutely mandatory. That's, I know a kind of a somewhat unsatisfactory answer, but, it's one consideration of many. And the committees also asked for additional information about the prevalence of sex crimes not resulting in conviction. According to the Rape, Abuse, and Incest National Network, less than 1% of sexual assaults result in felony convictions. Also provided is some information concerning how other jurisdictions approach this issue. A couple of jurisdictions, including Berkeley, California, and the city of Detroit, don't consider arrest records at all, including, any kind of related to any sex crimes. The District of Columbia, however, has sort of, what you might see as a compromise approach in that they do not consider arrests related to sex crimes, but they do consider pending criminal accusations concerning certain sex crimes. And they define those pending criminal accusations as, it's a formal charge in court. And so similarly, if you would like to adopt DC's approach, staff has provided an amendment towards the bottom of page 6. You could define pending criminal accusation in relation to Maryland criminal law, and then you could permit the consideration of the pending criminal accusations or conviction records or sex offender registry status, but not consider a mere arrest. So I think that's kind of the first issue for you.
Thank you. Council Vice President Albernaz, and that'll be followed by Councilmember Raymer.
Thank you. And Christine, great job. Really appreciate you digging into this and doing the level of analysis that you have proposed here. I think, speaking for myself, option 2 makes sense. I think it does address the concerns that I had raised and others as well about the nature of sex crimes, and you confirmed in your analysis the stark reality that unfortunately most of these cases are not reported in the first place, in part because of the very difficult nature in making convictions. And many of these cases do in fact disproportionately impact Black and brown communities. And so I think that this option 2 strikes a balance of acknowledging, which the bill acknowledges up front, that sex crimes of that nature and those convictions are obviously serious offenses that should be something that landlords inquire about for the protection of everybody involved, because there's more than just one party here. There's more than just the person trying to seek the rental. There's also the folks living within that arrangement and their rights as well. So I would move option 2 forward as an amendment.
It's been moved for option 2 by Council Vice President Albernas. Is there a second?
Second.
And that was seconded by Councilmember Reamer. Thank you, Councilmember Albernas. Did you have anything further? If not, I'll return to Councilmember Reamer.
Nope.
Thank you very much. Councilmember Reamer, please.
Thank you. I think Council Vice President Albernas said it quite well. Thank you, Christine, for the detailed work you did. This also for me was just, a concern that we be able to not place someone in housing where they are actually a threat. And I think that this is a very fair way to think about that. If there is a pending investigation, and as the research shows, unfortunately, very few of those incidents are even charged. And so they are, I think, likely to be more serious. So I think this is a good way to handle this most difficult part of the conversation. Thanks.
Thank you. Councilmember Jawanda.
Thank you, Mr. Chair. And I do also appreciate the additional research that was done by Ms. Wellens and others. I think, as is pointed out from a legal matter, I'll do the legal part first. I think it's really important. HUD guidance says no arrest. And so I think moving away from arrest which both of these do, is a really good thing, because I think that would put us in danger if the law were challenged. HUD guidance would certainly be looked at as a potentially a violation here. I don't think that one of the questions I had when I read the packet and read the DC law, I was wondering if that had ever been challenged, because that almost seems like an analogous a complaint, which I'm assuming is in the form of an affidavit, or there's a complaint that comes forward, which would usually, not always, but in many cases, is a part of the decision to make an arrest. That this would almost be even a lower level of ability to discriminate against someone who there's merely a complaint. So I wanted to ask if you don't, Ms. Wellens, I would understand, but this pending criminal accusation is written accusation that an individual has committed a crime in the form of an indictment or information under the Criminal Procedure Article of Maryland Code. Is this saying that there has to be an actual indictment that's put forward by a state's attorney? Is that what this is? Am I reading that correctly?
Correct. And I think you raise a really excellent point. I was wondering the same thing. Just criminal accusation does not sound like a very robust standard, but the way that's defined in DC and the way that it would be defined under this amendment would be requiring the written indictment or information. And so that would be, filed by a state's attorney who believes that there's probable cause. The judicial officer would have to agree there's probable cause, or in the case of the indictment, a grand jury would have to agree that there's probable cause.
Right. And so it's often well, I won't say that. What I will say is, I think we have to stick to the premise that, you're innocent until proven guilty. I'm very sensitive to the fact that many of these cases go unreported. It's one of the reasons I introduced a bill that we all passed, thankfully, to lower the standard of when you can claim sexual harassment and other forms of harassment because it was too high of a standard. And I think that was important, but I don't think we should be denying housing. The problem with this is when you deny basic necessities to people, you actually make it more likely that they're going to commit crime. And that is at the core of this issue. And so whether you're denying someone a job, in the case of the ban the box legislation I went forth, or you're denying someone housing, those are the two critical components that are most directly tied to your ability to do well and to get on the right track in life, regardless of where you are in life. And so I just don't think that we should be sending the message that, again, if someone has accused you, and we know there's accusations, there's even grand jury things that are thrown out all the time, and actually the same population, when you have miscarriages of justice, it disproportionately happens to this same population, to people of color, people who are low income, people who can't afford representation. So I think you're making it harder. And I understand the willingness and the concern, and I share it, but I don't think it's going to accomplish what we want to accomplish here. And that's why I think you have the HUD guidance. That's why I think you have the guidance from the Homeless Persons Representation Project, in that these are folks that you don't want to set up another barrier. There's already discrimination in housing. We don't need to add another layer. So I think we should stick with, I know there's a motion on the table. I won't be able to support it for those reasons, because I think we should stick to what is done in Detroit, what is done in Berkeley, where I'll remind you, Mr. Reamer, you're from. Well,
I'll have you know, I'm from Oakland, California. Thank you very
Oakland.
much.
I'm sorry. Neighbor. I'm sorry. My fault. So yeah, I just think I understand where people are coming from, but I can't support the motion. I think we should keep it clean and go with the other option mentioned in the packet to remove it. Thank you, Mr. Chairman.
Thank you, Vice President Albornoz.
Thanks. I just want to clarify, it's not just the lack of reporting on the front end, it's the lack of convictions on the back end too. That's my concern because of the nature of these cases. So that's why for me, this just falls in a different category. I respect tremendously what you're saying, Councilmember Jawando. I don't disagree with the general premise. It's just this specific category is of serious concern to me, and sex crimes often do involve children. And so that's for those reasons, I just felt that this was a reasonable approach.
Thank you, Councilmember Glass.
Thank you, Mr. Chair. Ms. Wallens, appreciate, as others have shared, the deep dive and the research that you've done for this second conversation, and appreciate the thoughtfulness in which everybody's coming at it. This is not easy. I understand it, but when we think about what the goal of the legislation is to get people off the street and to deter them from going onto the street. And I appreciate the words of Councilmember Jawando. Ultimately, I do not think that landlords should be the judge and jury. And that's what this comes down to. This empowers landlords to have a whole new role in our system where they can then deem anybody they want, anybody who, according to the second option, is pending a criminal accusation, as guilty of that crime, and deny them housing, which I think is basic service. And so I do not have a vote, as you all know, but I, as one of the sponsors of the legislation, would not support option number 2. I think we have to focus and center ourselves on what the goal of the legislation is, and it's to deter people from going back onto the street. Thank you, Mr. Chair.
Thank you, and I appreciate that as well. However, I do believe option 2 is something that I'm going to be voting for, and my reason being because it is a higher bar. It has to be written pending criminal accusations. It's not. I believe that in those instances when there is something that has already gone through the the beginnings of the judicial system. I believe that a landlord has to be concerned about who they're renting to and for the safety of the other residents in that building in many cases. So with that, I am going to support that. I see Councilmember Giwando.
Thank you. I just briefly wanted to make a point that unless you have a situation where an officer arrests somebody because they're targeting them, which certainly there is misconduct, I would just let you know that normally there is conversation between, there's not going to be an arrest unless they think they are likely to get a charge from the state's attorney. So I just want, as a normal practice, I just want to make so there's kind of a very connectedness to this arrest. While it may seem like a higher bar, I don't think it's as higher as maybe we think, in that officers don't tend to arrest people if they're not going to be charged with anything. And sometimes that does happen, but most of the times it does not. And so I think this is kind of tantamount to the arrest standard. And the other thing I just wanted to make is that, just to be clear, under any scenario, whichever approach we take, any conviction or listing on a sex offender registry list, which are available today, all that information continues and would be used. And so I think that is the appropriate standard. And I think Councilmember Glass brings up a really important point, that this gives a power to the landlord to discriminate based, and I understand my colleagues think for a good reason, but it is allowing people to discriminate. So I just wanted to make that point as well. Thank you.
And I appreciate that as well. I believe that we have to be clear, though. This would allow a landlord to make a judgment based on an accusation, but not based on guilt, because they haven't been found guilty. But it certainly is an accusation. It is a written accusation beyond just a simple arrest. So the way I'm reading it. But at this point, Councilmember Reamer, please.
This is, one of the hardest issues. I get the principle here. I also put myself in the shoes of a person living in rental housing. And would you want to know that someone who is being actively investigated for a sex crime moves in next door to you, and your landlord doesn't have the ability to find out about that? That is really tough. So anyway, understand.
So,
I voted.
Thank you very much. So at this point, I don't see any other speakers. I am correct on that. Okay. At this point, we have a motion by Vice President Albornoz.
I think Mr. Stowe, Director Stowe, I'm sorry, but were you trying to say something, sir?
Yes, sir. I was, Mr. Chairman.
Thank
Council.
you.
Thank you so much. Just real quickly, as I'm reading also to all of this, you may remember that all of this really goes into a decision to rent or not to rent, as far as it is concerned, or provide housing. That ultimate decision is not what's being guaranteed here. It's just access to the opportunity to be fairly considered for the housing opportunity. And as I'm looking at the second option, it was suggesting that persons have then the right to make inquiry into that particular accusation. As I'm reading it, unless I'm missing something, that would not mean an automatic decision being made as a result of being able to make that inquiry. So still maybe the opportunity then for there to be explanation, further discussion with that particular tenant about what this was all about, and still ultimately a chance maybe to be considered for housing in spite of the accusation that may be yet out there. So I just want to kind of point that nuance out that I'm reading, at least from my perspective.
And that's a very, very, thank you, Director Stowe. And that's a very valid point. This is not saying that they could not rent to them. This is saying that they could inquire as to what the situation is. So I think that is another way to clarify this. But based on that, unless I see anybody else, Councilmember Giwando, anybody else want to speak at this? I didn't see Mr. Stowe, and obviously, yes, Council President.
Thank you, Mr. Chairman. I apologize for being a little bit behind on this since I had to be in Annapolis for the first work session. But Mr. Stowe, does that mean does the county executive have a position on this issue?
Well, specifically, we wanted to certainly be supportive of what council determined on this. At the end of the day, it does come out to mean that we still provide the support that this bill is really aimed to do, and that is to provide the underpinning for our homeless communities. And at the same time, we did hear some pushback from those who are in the private rental business about the comment that I think was made minutes ago about who is in the community.
Right.
And so without being discriminatory and in all, this ties directly into ban the box as far as employment is concerned. Ultimately, we're talking about fair access to the process. Do I get the job opportunity to be considered fairly? And does my application for residency also get a fair, again, a review without prejudice? And if it is, let me have an opportunity to explain.
So does that mean your office and the county executive favor option 1 or option 2?
No, I should say to me that we don't really have an opinion on which option. I think both, Mr. President, accomplishes, I think, what the aim is. At the end of the day, what you have is, it seems to me anyway, the opportunity to follow if I would need to make a decision right now, probably follow the advice and the practice of what's happening in D.C. It seems to be something that's fair. And because it does not, in fact, guarantee the outcome, the decision to rent or not rent, to me, is where the fairness, I think, is still in place.
So that is option 2. Okay.
Okay.
All right. Thank you, Mr. Chairman.
Thank you. So Councilmember Joando, did you have something else?
Just very briefly, I appreciate the comments, Director Stowe. I just think there's no other reason you want to know that information unless it's to consider not to rent the property. I mean, I think the idea that we're going to, I just want to know so you can explain to me what happened. That's not that I just don't think that's what's happening here, and that's okay if people agree with that being the case. But I just don't want us to have the fiction that's likely outcome of this.
Let me just comment by simply saying this is that, what you just suggest in this case, Councilman Joando, is a case also in the ban box for employment. And the whole idea is that, it's my understanding anyway, and by making these two particular laws sort of mirror each other in their own context, is to suggest then that persons want the opportunity to be able to say and to be able to comment on their own behalfs what the situation in fact is relative to an accusation, relative to a long occurred act of some sort of violation as far as the law is concerned, and where I am today. That may have been then. I'm here today. Here's my situation as it exists at this very moment that I'm applying for this housing opportunity. And I would like to have the opportunity to be evaluated on the basis of where I am right now and not based on whatever prior activity would have occurred. And so I think that was what I thought you all were trying to be able to put in place as you look at this.
Mr. Chair, can I?
Yes, please, Councilmember Glaze.
So I appreciate this dialogue, which leads me to a question back to Ms. Welland. So a pending criminal accusation, how long can pending be in this matter? Because what Mr. Stowe just said is allowing people to explain themselves, right? And whether or not circumstances have changed, their lives have changed, explain the circumstances. And so I'm curious how long a pending criminal accusation might be.
Right. Thank you, Councilmember Glass, for the question. I can't give you a precise answer, but in theory, you're entitled to a speedy trial. So, I mean, things should move somewhat expeditiously, but I'm assuming it could be, a period of many months that it might be pending, if not years, if you consider appeals. So pending, it will depend on the particular case.
Okay, and I understand not being able to determine what jurisdiction, or we're talking about Maryland and Montgomery County, so that's where the pending presumably would be, unless someone's moving here, I guess. So actually, I correct my own statement there. But the fact being, and again, I want to come back to the central point that Councilmember Jawando raised, and then I'll stop, is that if anyone is convicted of a sex crime, they can be rejected. That is the point that we're trying to make. We want people to be safe in their community. And once a court of law determines that they have broken the law, then we empower the landlords to make that determination. And again, until a court of law makes a determination, I don't think we should empower landlords to have that role of judge and jury. Thank you, Mr. Chair.
Well, but that lends itself to another question. If that person were convicted, you knew that there was these pending allegations, and that person is convicted, the landlord at that point, I don't believe, can come back and say, I'm now breaking this lease. How would that work?
Depends on the term of the lease, I would think. What's in the lease, but they also could choose not to renew. But yeah.
But you know my point. I mean,
yeah. No, I get your point. I was actually going to raise another point about this legal issue, which is not insignificant. Not only are we empowering the landlord to discriminate and find out this information and use it in the way that they wish, you're also potentially taking away rights of the defendant in their trial. As far as self-incrimination, to Director Stowe's point of having to explain what did or didn't happen or why it did or didn't happen to a non-related third party pending a court case, that is, no lawyer I know would advise anyone to do that. And so I think, again, this is another unintended consequence of straying from the intent of this bill for I understand really sincere and caring reasons that we all have. But I just think, I just think we're going down a path here that you don't want to have that conversation, because you can't have it if you're in that position, and you want to have people safe and fairly housed, and particularly people who have not been convicted of any sorts of crimes that are enumerated here. So I just think that's another thing, another unintended consequence of this.
I think we probably had a good discussion on this topic. It's certainly an important one, and it deserved a good discussion. But we do have a motion before us for option 2. It was made by Vice President Alvernaz and seconded by Council Member Reamer. All those in favor of option 2, please raise your hand. And that's Councilmember Alvernaz, Councilmember Friedson, Councilmember Reamer, and Councilmember Katz. That's 4. Those opposed to this option, please raise. Oh, I'm sorry, Councilmember Hucker. Are you opposed?
You haven't called on my position yet. You're
okay.
about to.
All right, very good. I didn't see your hand. So, Councilmember,
thank you for
those
asking.
opposed, please raise your hand. Councilmember Jawando, the Council President Hucker. So it is 4-2. Okay, very good. Thank you. Sometimes the Zoom stuff can be a little trying to figure out where people's hands are. Okay, very
Absolutely.
good. So option 2 passes 4-2. Okay. Next, Ms. Wellens, moving right along, please.
Thank you, Mr. Chair. Moving right along to item number 2. This issue, the committees discussed during the prior work session, but there really wasn't sufficient time to come to any resolution. The issue relates to how the bill applies to certain nonprofit screening procedures for their clients. As you'll recall, the Montgomery Housing Alliance brought up the point that they provide more than just housing to certain vulnerable groups. And they asked that language be inserted to ensure that nothing in the law would interfere with organizations' processes of conducting criminal background checks, including the timing thereof, as part of the assessment process to identify needs for therapeutic and other support services to further housing stabilization. There is a potential amendment drafted by staff just for your consideration, in order to provide, if you wish, a partial exemption to certain nonprofit groups in the event that they are conducting the criminal record check on an individual for the purpose of assessing therapeutic and other support services for the individual. And as drafted, this amendment would exempt the provider from two things. It would exempt them from the requirement that you can't put the question about criminal history on the application. So they would be able to put criminal history inquiry on the application. And then it would exempt them from the timing of having to wait until after a conditional offer of housing is made. They could start the criminal background check earlier in the process. What they couldn't do under this amendment would be to consider the enumerated misdemeanor crimes as part of the decision of whether or not to grant housing. That part of the bill would still apply. I don't know if you want to invite Ms. Harris to might have some additional helpful context on this, and happy to try to answer any questions. Thank you.
Okay, thank you, Ms. Harris. Did you?
Sure. Sorry, I apologize about the barking dog. Well, I appreciate the intent. I do worry that exempting the affordable housing from this process is going to severely limit the ability and the intent of the bill, is to actually get people access to housing that is affordable to them. And just for context, we do a lot of permanent supportive housing programs, other kinds of programs. We offer lots of case management. We do not do background checks, criminal background checks. We do a clinical assessment to determine the needs. So it's not entirely clear to me what information they would glean from a criminal background check that would inform their case management practices.
And I guess Ms. Wellens, and I'm going to turn to Councilmember Reamer. He's the first person on the list here. But Ms. Wellens, if a organization that was leasing an apartment said that as part of this lease, I will lease this apartment to you, but you have to be in some sort of therapeutic discussions, and would that certainly would be allowed as part of the lease, wouldn't it? I mean, if they said, look, I'll lease it to you, but you have to be in rehab or whatever is necessary for that person to be in, this would not allow that, wouldn't it? I mean, they would be allowed to do that, correct?
That's an excellent question, Mr. Chair.
Well, excellent question, because I didn't ask it well, but I know what I'm trying to ask.
Yeah. This is a good question because I mean, my answer is no. I don't believe that it would prevent anyone from doing that. And I would defer to Ms. Harris, might be able to speak better to knowing the actual processes, but I don't think that the intent here or that the outcome here would be that you can't, provide housing to certain types of groups. For example, you meet certain criteria that you're, homeless, for example. It specifically relates to the criminal background checks and whether you've had certain arrests or convictions. So I don't see that it would hinder the provider from asking about other, therapies or other situations that apply to the prospective tenant.
Thank you. Councilmember Reamer.
Well, I'd like to ask Ms. Harris, why do you think this would potentially have an impact? It's been my interpretation that the reason the nonprofit housing providers are asking for this is so that they can offer the housing, but do it in a way that's appropriate based on the services that they want to provide to a person, rather than, denying them the housing. Of course, this isn't a This doesn't say that if you don't pass the background check, you're not eligible for housing. It just says that the provider can ask and do the check. Why are you concerned about what the consequences might be?
Well, I think that historically, people experiencing homelessness have not been able to access housing through our affordable housing developers. They have been denied for a variety of reasons, including their criminal background, their credit history, poor rental history, all the things that make it harder to be able to access housing moving forward. And I'm not opposed to allowing them to do the criminal background. It's just not clear to me as a clinician what information you're going to glean from a background check that will inform your services. You can ask other kinds of questions to get information about what are the needs of this individual that do not require knowing whether 10 years ago they were arrested for open container, right? It's not that I'm having a hard time seeing the direct link between knowing your criminal background and being able to provide therapeutic services.
And do we have any nonprofit housing providers with us who are on the call that could provide a little more information? I mean, I get your point about the clinical evaluation being the one that would seem to apply rather than a criminal background check. And it makes me wonder if maybe, to your point that historically there's been a challenge for these individuals to gain access, it might be that the nonprofit providers are saying to themselves something like, well, there's a higher burden on us to keep our community safe, and so we're going to be more stringent, and so we're going to apply a higher bar or something like that. Do you think that's kind of what's been going on, or I don't know?
Yeah, it's hard for me to speak for them, but perhaps that contributes to it.
Interesting. Okay.
Thank you. Councilmember Juando.
Thank you, Mr. Chairman. And Ms. Harris, thank you. That's really helpful information that gets to the core of this. I think we can't be overstated that this is a population and who already has significant barriers to getting housing. And this bill is about how do we remove one of those barriers, right? And that's inquiry and use of past criminal history, which can often be relied upon, and provide a remedy if there is a applicant who feels that it has been used improperly, to go to human rights and get that investigated. And so there are many other barriers. You mentioned some: credit rating, past rental history, just the appearance of homelessness, right? Just being homeless. There's a long list that aren't related to, that this bill won't, we have to accomplish going and getting at those from other angles, but we want to remove a big one, and which is, past criminal history. So I think the idea that we would exempt the very providers that are most likely to provide the most affordable housing makes no sense. And when you combine that with the fact, regardless of what the intent is, there's discriminatory intent, and there's discrimination that happens through disparate impact. That is just de jure versus de facto. And the fact is that formerly homeless, formerly incarcerated are not accessing these properties. And so we don't need to create another way for them not to access it. So I think this is, we should definitely not create this exemption, because it would fly in the face of the intent of the bill. Thank you.
Thank you. Councilmember Glass.
Thank you, Mr. Chair. So again, I just want to keep centering us on what we're trying to do, or at least what the co-lead Chair Katz, myself, and those of you who've co-sponsored this legislation are trying to do, and that is provide housing for individuals who need it. The most vulnerable members of our community, those who have been homeless and those who have been incarcerated, essentially. And when we look at our housing stock, there isn't a whole lot of housing that is available to them. There's affordable housing, deemed affordable housing, that we're talking about right now, which in Montgomery County is established basically through our nonprofit partners. And whether they're MPDUs or any similar types of units through the different types of arrangements that our incredible nonprofits provide. And I say that as someone who is once vice chair of one of our incredible nonprofit housing providers here in Montgomery County. And I know the incredible work and the totality of the work that they provide. Everything from housing to education to other types of recreation activities for their tenants. But if we are to remove our affordable housing from this, what is left? And I leave that question open-ended. There's not a whole lot left. That's the answer. There's group homes, and we're going to come to that one next as well. So the more we remove from the housing available, the less housing there ultimately will be. Thank you, Mr. Chair.
Thank you, President Hooker.
Thank you, Mr. Chair. If you'll allow, Mr. Chair, I did want to follow up on Councilmember Reamer's question. And again, I feel like I'm a little bit behind on this issue after missing the last work session on this. But had the nonprofit housing providers, how would they grant housing but accommodate the access, the information that they gleaned about somebody's past criminal record? And had
You're breaking up, Councilmember. You just
There
you are. You're back.
Sorry, better?
Better. We can hear you.
Sorry.
You might want to turn off your video, Tom.
Okay, go ahead.
Better? Sorry, I apologize.
Yeah, we can hear you.
I was wondering. Thanks. I was wondering if Councilmember Reamer, if the nonprofit housing providers had said that they were willing to interested in granting, they just wanted the benefit of the information, but they were still committed to granting the housing, as you were saying, if that was like their.
You're.
Oh, the answer. I thought they were.
You're breaking up. You're breaking up.
All right. Is this better? Sorry.
Yep.
I apologize. If this is better.
Don't worry, Tom. 5G is coming.
Thank you. So I was just wondering if the nonprofit housing providers had said what Councilmember Reamer was talking about, that they wanted to grant the housing, they just wanted the benefit of the information, or whether they were getting the information potentially with the, if we were giving them the possibility of declining to grant the housing in the future. Is that their position, or are we speculating on that? I don't know the answer. I don't know if they had given that testimony or something.
Well, if you directed to me, yeah, I mean, that was their position. They specifically said, it's in the packet on
Thanks. Okay.
page 7, that they want to call our attention to special circumstances, that it's their processes of conducting checks and the timing that helps them identify the needs for therapeutic and other support services. And so they were asking for the exemption on the grounds that the ability to do the check was relevant to their ability to do service design. Amanda Harris is basically sharing, she's not quite sure why that would be.
I thought you were saying that they wanted this information so they could still grant the housing. It would just be in a sort of different location or something like that.
That's what's inferred. That's what's inferred by their testimony, is that it's as you said, they want the information so that they can provide services or perhaps location.
Including housing? Like, what would that look like? I just don't, and I wish they were here to answer these questions, and I don't mean to put you on the spot, but I hate to make policy sort of speculating on their motivations here. I sort of agree with Ms. Harris on this. I'm for the housing. I thought they were in the business of that. I rarely want to deny anybody information, but if it's going to result in discrimination that doesn't ultimately, if it leads to more sensible placements or something like that, maybe I could see that if there was a guarantee of the housing still being granted. But in this case, there's not, right? So Director Stowe looks like he's trying to get in. Mr. Chairman, I'm not running this one, but that's what I'm struggling with a little bit to figure out what their position is. If they're sort of hiding behind that rationale, but they're still intending to grant the housing.
Okay. Director Stowe, are you trying to get in?
Yes, sir. I was just going to say that I did have a discussion with Dr. Crowell, and actually called me about this particular bill, and the concern that you articulated is exactly as I understand from him. Now, again, I don't mean to speak for him, but the conversation that we had suggested then that the therapeutic assessment was the critical element here. He did not get into necessarily about the actual placement of a person, but it was clear to me then the discussion was about how to properly assess the individual who was seeking housing to ensure then that all the resources that that person might need to ensure their success would be certainly considered, in the very beginning of that process. And so that was the reason they wanted to make sure they had access to the information that might help them reach that decision. But again, to say specifically, did he talk about the placement? We did not have that conversation.
And to Ms. Harris's point, and Ms. Harris, please correct me. It's always when I'm wrong. It's never if I'm wrong. To your point, that they would not necessarily need the criminal history in order to be able to make the clinically necessary to get the clinically necessary information. Is that correct?
That is correct. That is correct. We offer all kinds of clinical services and do not do background checks in order to provide those. That's true both in services to end and prevent homelessness. It's also true in our partners with behavioral health. Like, the criminal backgrounds are not a regular part of the clinical assessment. And it also should be noted that many of the folks that are experiencing homelessness that would be accessing these programs are going to come with support services anyway. They're going to be part of a permanent supportive housing program or a rapid rehousing program. And so if they need to have that clinical information, we have clinical staff that have been working with the tenants and can easily share that information with the landlord.
And if the landlord wanted to make it a part of the lease that said, I will lease you this property, but you have to, get these various therapeutic remedies, they could do that. They don't need the criminal history for that. Council Vice President Albernauz.
Thanks. So the Montgomery Housing Alliance includes Housing Unlimited, Montgomery County Coalition for the Homeless, Montgomery Housing Partnership, Rebuilding Together Montgomery. They're all on record in support of this bill. They're not asking these questions to make it more difficult for people to access these particular programs. These are the only programs set up in many instances for the folks that have these very holistic and often mental health related needs. And so these are the good guys. These are the organizations who have been, continue to, and will continue to provide housing options for individuals that potentially have been incarcerated. And so they're in favor of this bill. And what they're asking for is the ability to do a deeper dive so that they can provide the appropriate construct and support services, because there are unique circumstances in which an individual may not be forthcoming about their mental health issues or about some of their needs. And so this just gives them additional piece of information to be able to provide the support that they need. And it is unfortunate that they're not here, because I do think that they're not trying to make it more difficult or less likely that folks who are in this situation will find housing. On the contrary, their entire mission is to ensure housing for everyone. That's why they exist. And so I think that it would be helpful to better understand, and I very much appreciate, and although I'll be candid, I had a hard time understanding Mrs. Harris because of the dog situation. But I think that it would be helpful to have some follow-up specifically from providers. And, I do take Dr. Kroll's position here very seriously as well, because he has a behavioral health background. He is a clinical psychologist. And so if the head of our HHS department, who I know is not on record here, as a clinical psychologist, is stating that it may be helpful in an assessment of a case to know whether or not a person has been incarcerated, and understandably, some people may not be forthcoming about those issues. Again, it's to provide more and better wraparound support so that these organizations can ensure that not only do they provide stable housing, critically important, universally accepted, that's what we're trying to do here, but that they're able to stay in that housing, because just providing the housing is the first step. Ensuring that they have holistic support to be able to address the workforce development needs, to be able to address the mental health needs, to be able to address the substance abuse needs, to be able to address whatever the issues were that led to homelessness to begin with are addressed. That's why these organizations exist. So I don't think it's reasonable to frame this as these nonprofits trying to put up a barrier in order for them to be able to prevent people from accessing their services. Their very mission is to provide the services for these residents who especially have a hard time finding housing. So I would recommend or suggest that we do seek additional information from these organizations to find out more. I appreciate Mrs. Harris's comments, but I'd like to get a second opinion here, frankly, on from a clinical perspective from these organizations. Why did they bring this issue to our attention in the first place? And we have their letter, which is enlightening and helpful, but I think it requires some follow-up.
Thank you. Councilmember Friedson.
Yeah, thank you for that, and thank you to Councilmember Alvarez for raising the coalition and who it includes, because I think that we were devolving a little bit from the conversation where the suggestion of a coalition that involves Montgomery County Coalition for the Homeless, suggesting for ways to not house the homeless. I just don't think it is what the intention is here. It's a challenging situation to try to understand this. It's also challenging to understand because there's several different people from the executive branch on this that seemingly have different opinions on how this should be handled. I'm not quite sure if there are if there's one position, multiple positions, or no positions from the executive branch on this. I'm trying to kind of reconcile that. I do think it would be or would have been helpful to have the folks who we're talking about here actually explaining the need for it. I think we're projecting what we think or inferring what we think. And so I just would point that out. My understanding, based on the letter that we have, the information that's in the packet, what was shared with us at the last work session, is that the goal here was to allow for organizations whose mission is to support individuals with challenges, to help them get services that are needed, clinical and otherwise, that they have the ability to be able to do that, and that this bill not unintentionally prevent the very people who we're partnering with to help us not be able to be put in that position. Ms. Harris has raised an interesting question of whether or not this information actually is needed, why it would be needed. I certainly am not in a position to question one side of this or the other. But the way that the amendment was written, could you read it, Ms. Wellens? Because my understanding was the information that was being attained here was exclusively for the purposes of the services. So could you just read it? Because I think it's important. We've had a lot of discussion, but I think it's important to go back to what we're actually discussing.
Sure. Thank you, Councilmember Friedson. The particular amendment would read that the requirements of subsection C and D, and just for reference, those are the subsections pertaining to having an inquiry about criminal records on the application form itself, and about the timing of when you can do this. The subsection C or subsection D relates to the timing, I believe, of having to wait until after the conditional offer. So this would say those requirements would not apply to a housing provider that is exempt from federal income taxes under Section 501c3 of the Internal Revenue Code, and consistent with the housing provider's mission and policies, conducts a criminal record check on an individual for the purpose of assessing therapeutic and other support services for the individual. So it was at least an attempt through the language to be fairly narrow towards saying that, yeah, we're doing this check for the purpose of helping, hopefully in theory, helping this individual with support services. It would have to be consistent with the mission and policies of the provider. And it would be a limited exemption. It would not exempt the provider from the restriction against considering a number of low-level offenses and misdemeanors when deciding whether or not to grant housing.
So based on the way that it is written, what we're discussing here is that it has to be for organizations that have a mission beyond just an MPDU, as was discussed earlier, or some other, which largely are created by for-profit providers that wouldn't qualify anyway, but has to have a mission dealing with housing folks who otherwise wouldn't be housed, and has to be used for the specific purpose of providing services, including clinical services. So I just want to, that's what the amendment is. We kind of have talked our way out of, I think, not in terms of committing, or not committing to what we're trying to do here, but I think we started talking about some other things. I just want to make sure that that is what we are discussing. I do think it's important that we not put an obstacle in the way of organizations who are critical partners for us to actually achieve the goals that we're trying to achieve in this, that we all share. It seems that there's disagreement even within the executive branch of government, even within the same department, of what and how this information, what it would be, how it would be used, why it might be needed to provide the services. I tend to think that, I share Councilmember Alvernaz's point that these are the good guys. I mean, these are folks that are helping to provide housing to the very individuals who we are trying to help here. They're our most important, most significant partners in that. So, I think if we can ensure that the purpose of this is to allow for services to be provided and to help with organizations with a mission in order to do that, then, I certainly wouldn't want to, put up an obstacle and have consequences that we aren't intending to have in this, broader bill, which is to ensure more access for housing to those who currently don't have enough of it.
Okay. Councilmember Glass.
Okay. I appreciate what the conversation Councilmember Friedson just engaged in, right? And again, focusing us on the matter of this particular amendment, and also appreciate the framing from Vice President Albernaz as well. Absolutely, we are all on the same team here, and any inference to the other doesn't exist. There is no straw man here. We want to provide housing for as many people that we can provide housing for. And refocusing even further, the focus of this bill is to provide housing opportunities for those who are homeless and incarcerated. And continuing the conversation that Councilmember Friedson just engaged in with Ms. Wellens. So Ms. Wellens, you just talked about the amendment that is before us, right? That's in the packet. When you, in your opening comments, you alluded to another amendment. Has that been brought up in this context yet?
It is not.
Ms. Wellens, can you address the amendment that has been prepared for possible introduction. Clearly not by me, not as a member of either committee, but I think it's pertinent to this conversation.
Okay, so I think you're referring to an amendment that I was asked regarding this. So regarding the same potential exemption, the same language.
That's correct.
So there was, so I don't have a.
I have it. Yeah.
Oh,
Okay.
okay. Oh, okay. Well, so.
Well, if you want, if I can interrupt just for a moment, I've been torn on this. I believe that just the way this conversation is going, that is what in my own mind I've had the same difficulty. We want to make certain that the providers can provide and that the people that need housing can get that housing and the help they need, to other people's points, Vice President's point, and that they can stay in that housing. That's the goal here, is to not have homelessness. And that is why I had come up with the concern, and I asked Ms. Wellens to draft something that said that the requirements would be that it has to be federally exempt, federal income tax exempt from federal income taxes under Section 501c3, and B2, consistent with the housing provider's mission and policies, conducts a criminal record check on an individual for the purpose of providing, and I'm emphasizing that word, providing therapeutic services, case management, or other support services to the individual. And that's what I considered prior to today's discussion, but because of today's discussion, I don't know whether that amendment actually does what we're trying to do. I think it goes further than what we have, but I'm not sure this is exactly what we want. And none of us want to have a weaker bill. We want to have a person have a better life here. And so I don't know whether or not, and there's other speakers on this list, but I don't know whether or not we would be wise, and not that we need necessarily does any of us need a third committee meeting on this, but whether we'd be wise to get the additional information before we actually consider what to do on this amendment. And I'm sorry that I interrupted you, but that's where I am. Thanks.
Even as one of the sponsors, I'm trying to follow the bouncing ball here. And so I wasn't quite sure. I had heard of that amendment, but didn't know where it was. And so so you had asked for that. You are not introducing it at this time, but
not at this time.
But let me just say that I would do that as a friendly amendment, because really what we're trying to do here is make sure that the housing providers, the nonprofit housing providers that provide that holistic approach that everybody has talked about, notably Vice President Albanaz and Councilmember Friedson, those that are providing that holistic approach, making sure that they can continue doing so and they would be exempt. But not all housing providers do that. Some of them just build a house. Some of them just build an apartment. And they're not part of the wraparound services that we are referring to. And if you're not part of the wraparound services, then this is just another way of shutting the door to somebody. And just because the Housing Alliance as a whole sent this letter, there are nuances within. And I think that amendment gets to the nuance. And it allows those that provide the holistic approach to continue doing so, and those that just build walls and roofs to conform to this housing policy so more people can be housed. It's also been shared with me that I think there are some housing providers or advocates. I think Susie Sinclair Smith might be in a waiting room. If she wants to provide some context about that Housing Alliance letter or other things, Mr. Chair, I defer to you and the other co-chair as well. So if the power behind the interwebs, I don't know if it's Nick or so, might allow Ms. Sinclair Smith to appear.
And we're certainly going to ask for that. We have other council members who want to speak. Yeah. But by the magic of text, I have received a text or two that says, could we defer this part of it to the full council so we know what the providers want and the county executive's position? So whether or not therefore we would not have to have a third work session on this. We can actually move this to the full council and get this accomplished. Council President Hucker, and then I'm going to go.
Since you're reading my
Yes, I'm outing you. Yeah, go ahead.
I'm reading my text, and I didn't fully understand the last amendment because you faded out for a second. But I was going to suggest maybe this is the same thing, just amending the amendment to clarify that the information gathered in a criminal background check may not be used to deny housing based on the information, but may be used to provide additional therapeutic services.
But if we're going to me, candidly, at this point, I'd like, and we're going to hear from Ms. Sinclair Smith, but I believe at this point we should figure out exactly what we have before we actually figure out what the amendment should be. I mean, I think we're all trying to figure out the best path forward. It's just what is the best path forward. And with that, Ms. Sinclair Smith, please.
Sure. Thank you, council members and committees. I really appreciate this conversation, and this legislation is an incredibly important step forward in our successful efforts to end homelessness in Montgomery County. We, Montgomery County Coalition for the Homeless, does not do background checks. We are the largest provider of services exclusively dedicated to addressing homelessness. We believe that background checks has nothing to do with service eligibility or the upfront. We certainly, after we accept people into our housing programs, and we have 510 households in our permanent supportive housing programs, they have a 96% housing stability rate. We then assess our clients, and once they've got the roof over their head to get their life together and move forward, and then we determine the need that they have for services. I do think that the Montgomery Housing Alliance statement might not reflect the views of all. I think it's an association of housing providers, and might not reflect the views of the groups that the full group, I'm trying to say this the correct way.
You're being very diplomatic, Susie.
Thank you, Sydney, but might not reflect all views. And I do think that the reason we've been so successful in our efforts to end homelessness, and we virtually ended chronic homelessness, which is the population that does have these significant challenges, is that we follow housing first, and we believe that once you get people into housing, then they can begin. We work with people where they are, and people come with ranges of challenges that we help them with, and we have great success rate. So if I may respectively suggest that I know that there would be a number of us who would be willing to talk to you after this to zero in more on this particular amendment. But I do think that it would create barriers.
Okay.
To housing.
Thank you. And I believe that for the first time in my life, I've seen your name as Suzanne. It's always Susie. Anyhow, Councilmember Jawando, please.
Thank you, Mr. Chairman. And I'm glad that Suzanne/Susie was able to give that insight. It actually made me adjust my notes. I was writing down here just a couple of things. So I was going to say one clinician, but now we have two, and one of the largest providers in the county that are saying they do not ask for this information. There's no need to, and that it could be a barrier to services. So I think that's one really important point. The other point, I want to echo what Councilmember Glass said, that I think we're all in this for the right reasons. It's just how do we get there? And this is where I think my particular hat as a civil rights lawyer and working on discrimination for a long time, it's so insidious that the intent doesn't have to be there. I think we're focusing on intent in the wrong way. We have to look at what is actually happening. Who is getting housed? Where are they getting housed? There was a statement by Ms. Harris that I wanted to see if she could expound upon. And if we are going to wait until full council, maybe we can actually get some data on it. You said, Ms. Harris, that there has been issue with this population accessing this type of housing. Do we have any data on that? Because if that is factually correct, it matters not in the world of discrimination, which what this law is about, to remove potential for discrimination in housing, whether it's intended or not. If it's happening, it's happening. So could you just speak to that? What data or where were you using to back up that statement?
I don't have the data available right now. I can certainly look at that. I do think it's important to note that there are lots of housing providers that we work with, so they are different.
Sure.
Golden Homes and Housing Unlimited are very different than some of our other housing providers. So I would have to go back and review the data to get a better sense. But I have heard anecdotally with the folks that we're serving that we have continuously had a hard time getting folks into affordable housing. Part of it is because of, like I mentioned before, the rental history, the criminal backgrounds, even source of income. Not if we have a subsidy that is not a year-long subsidy, it's only a 6-month subsidy, not calculating the income right. I mean, there's just a lot of barriers to access. But I can certainly pull the data for you and get back to you.
I can certainly confirm that as well. We have men in our emergency shelter who've been there way too long because of the barriers they face, and
yeah, I appreciate that, Susie. And Councilmember Glass started here. I think we need to come back to it again. This is about arrest records in housing. That's, and about not allowing that to be used as a factor. You look at the population. The most incarcerated, Maryland leads the nation in incarceration of Black men.
Mm-hmm.
Number 1, Louisiana, Mississippi follow. And Montgomery County is, and we're a great county, but we're not doing that well either. And
our homeless population is overrepresented by African Americans.
Right. And so what I'm saying is that we're talking about an overrepresented population in the criminal justice system, an overrepresented population in homelessness, and removing one of the many, many barriers that are described for that population. And then we have a clinician saying this is not needed in any way to provide services. And then the last point I'll make is the reason that I think this is just kind of like, it's easier for providers. There's a lot of people that need affordable housing. And so if you can, don't have to deal with credit history or criminal history, and, there's a lot of people who need affordable housing in Montgomery County. So I think that's probably why there's people in line that is, that also have need, and that are getting the housing. So I think that's get to the intent point. There might not be intent. But if there's people that are also in need that don't have these issues, you get the discriminatory effect. So I think, I'd be comfortable not including it, but if we want to push it later, I would just ask that data could maybe be part of the conversation as well, Mr. Chairman. Thank you.
Thank you. Council President Hucker, I had you on the list, but I don't know if you're still on the list.
I'll pass. Thank you. I think
Councilmember Friedson.
Yeah, thanks. So I thank you, Ms. Sinclair Smith. I think your points are compelling. I had thought about it in the way originally. One, I thought that the amendment was written in a way that was trying to focus to the goals here. And number 2, I thought about my grandfather who had a car dealership and had a program that he started that hired and trained and hired incarcerated youth to learn how to be auto mechanics. And specifically, the first question is, have you been incarcerated for the purpose of, having a targeted program to provide help so those individuals could get training and then ultimately get jobs. It was a really successful program. And so to have not been able to ask that question would have made it extremely difficult to have a program that was targeted to help a population of people that desperately needs help and support and just a chance. And some of those folks, by the way, were some of the longest term and best employees of my grandfather's business, our family's business, but also were hired by other places as well. That was the way that I was viewing this. Ms. Sinclair Smith has raised some, really interesting points. Council President Council President raised some good points, and the chair raised some points. My perspective on this is I don't know that anybody has actually moved this or seconded it. I'd be very comfortable with us moving forward without it, that it be noted in the packet. And it sounded like that's where, Mr. Co-Chair, you were heading with this. And I think Councilmember Joando's points of the data and some of the follow-up conversation to hear more directly from, our HHS director who raised some issues about this, a number of other points to nonprofit providers. And if we do need to take it up to add it later, we can, but I don't feel compelled based on what I've learned here today, where I've somewhat changed my view, at least at this moment, open to discuss otherwise, but just sharing my own perspective that I feel like we could take it up at the full council if need be, but it's not even an open question in the legislation. It's really just an open discussion point for consideration as part of the packet. So I just wanted to share that and clarify my earlier comments. Since the conversation has evolved, so too have my thoughts on how I approach this issue. And I'm very glad in particular that we were able to work the technology out to get Suzanne Sinclair into the room. That it would have taken me a minute if I didn't see her picture to even realize who that was.
So if it's all right with everyone, we're not going to, there's no motion, so there's no vote to start with. We're going to, so that we can move on with this legislation, we're going to not have, there's no motion on this anyway. There's no vote on this amendment. It can be raised, but we do want the additional information, please, Ms. Wellens, as best you can come up with it. And we would discuss it at full council. But I think that's the best way to move forward on this. And then we have one more suggested issue. Ms. Wellens, if you could please go through that. And I did note that I did want it to be noted that I know that some members have to be leave by at least 3:30. So, if we can accompany that as well, accommodate that as well, I'd appreciate it. Ms. Wellens.
Thank you, Mr. Chair. At the risk of famous last words, I think this will be a quick issue.
Well, I think, are you quoting Councilmember Reamer? I think that's what he said.
Yes, I'm doubling down on that.
I think the other two were the quick part.
So this third issue was also touched upon very briefly during the first work session. There wasn't really sufficient time to delve into it. It's at the bottom of page 7 of the staff report, and it relates to exempting rental housing with shared living spaces from the purview of the bill. As originally drafted, the bill would not apply to accessory dwelling units and owner-occupied properties. In the course of public testimony, there were some requests from landlords that the bill also not apply to properties where the owner doesn't necessarily reside, but the property is a building that has shared living space where you're renting essentially a room and you have a shared kitchen and shared living space. So the potential amendment for the committee's consideration would simply be to alter the definition of housing provider under the bill so that just as it excludes the certain owner-occupied dwellings as well as ADUs, that it would also exclude a building or portion of a building that contains individual living units as defined under section 29-1. So, and as you know, chapter 29 takes us into the housing code where the term is defined. You can see the definition there. I recall that at the prior work session, Chairman Katz brought up the point that the definition needed to be clear, that although the individual living unit itself doesn't have complete kitchen facilities, that the building still could have complete kitchen facilities. And I didn't propose staff didn't include a potential amendment to that effect just because I think that's and I would invite Ms. McCray-Moody to please correct me if I'm wrong, but I didn't want to change the definition in the housing chapter, which is used in the housing chapter for other purposes. But I think the interpretation of that definition is that it does include, that's what it's trying to get at, is when you're renting a room that, but the building has a shared living space or shared kitchen. Sorry, I hope that's clear.
No, I think it's clear
that's
to me.
the correct definition. The definition is.
Thank you. Is there any discussion on this point, on this issue? Councilmember Glass.
Well, I see a member of the committee, Vice President Albornoz, if you want to go before me.
Okay.
Yeah.
I did not see him. Yeah, Mr. Vice President, please.
Thanks. I don't know if Ms. McCray-Moody, you have this information, but about how many of these units are we talking about that fit into this category? Do we have an approximation of what the universe is of how many of these properties exist where you are renting out a room or
we don't know because we don't necessarily condone it. I mean, people do it. They get a license for a rental property, and then to maximize their profits, they may rent it out as individual rooms. We have no way of knowing. Our assumption is you got a single family license and you're renting it out to one family or one person, but we have no way of knowing how many of those people are renting them out as individual rooms. I can get you a number for accessory dwelling units because they have to license specifically as that. But in terms of people who rent rooms, I have no idea.
Okay, that's helpful. And just to confirm, Ms. Wellens, ADUs continue to be exempted from this discussion. What we're talking about is this unique circumstance that it sounds like is not tracked very largely because we're just not sure. But how many living situations are out there where you are just renting out a room or have sort of a congregate living space like this? But just want to confirm, ADUs not included.
That's correct.
Okay, got it.
Councilmember Glass, please.
Thank you very much. Good questions, Councilmember Albornoz. And the way the bill was written, ADUs and owner-occupied units are exempt. So if you live in the unit, you get to pick your roommate or your tenant, right? That's your prerogative. This is only for essentially group homes, of which I lived at once or twice in my adult years. But I appreciate Ms. Harris being here. Last time, we touched on this and she wasn't. But Ms. Harris, let me ask you, and I think this is a continuation of Councilmember Albornoz's question. So when people are exiting, the criminal justice system and exiting the homeless system, what kind of housing do they typically move into?
Shared housing. That is, yes. If people are not getting a housing subsidy, which only about less than a quarter of the people that enter our homeless continuum are actually eligible for a housing voucher, and then even less than that actually get it. So we have to find housing that is affordable and sustainable for them. So even when we house people through our rapid rehousing program, which is a short-term subsidy and case management, we try and make sure that we're placing people in a unit that they're going to be able to afford in the long run. These are folks that have extremely low income. They're either on a fixed income, on SSI or SSDI, or they're working minimum wage. They cannot afford a one-bedroom apartment. So this is typically the kind of housing that they're going to be accessing. I would say at least 50% of the folks that we serve would, one of their main housing options is a room rental.
And I appreciate that. And so if that number of individuals or that percentage of individuals are already accessing this type of housing. We want to increase it. We don't want to diminish it. And so we don't want to put any additional barriers to it. And that's why any potential amendment to reduce access here would do harm to what we're trying to do and to what you have just stated is working. So we want to encourage what works, and we want to encourage people to be able to find affordable housing in group homes. And so so I would implore the committee to keep the original language and not to amend it any further.
Ms. Smith, we'll get to you, but are there any council members that, Ms. Smith, please.
Sure. I wanted to concur. We have benefited from county and federal COVID relief funds to move men out of our shelter as quickly as possible to make room for new men who need emergency shelter. We've moved 131 men into permanent housing from our shelter in the last 6 months. We could not have done that without room rentals being available because they're the only affordable housing on the private market.
Council Vice President Albornoz, followed by Council Member Reamer.
Well, I guess my only, and listen, I agree in principle, but my only concern is if the unintended consequences here, if somebody can't conduct a criminal background check, will it make it less likely that they're going to rent a room to begin with? And so that's my only concern here. That's why I was asking about, the universe of these situations. And it sounds like, frankly, a lot of them are informal. You don't have a lot of circumstances in which somebody has filed for, a permit of any sort. You've got folks who are, many of our immigrants end up renting, in situations like this. And in some cases, they're renting literally a couch, not just a room. So I just, that's my only hesitation on this issue is it possible that the unintended consequences is that this actually diminishes our stock if folks that are formally going through some process, which sounds like isn't the case, are less likely to do so. That's my only hesitation, and I don't know that we can answer that question. It's a risk that we might be obviously having or willing to take, so that the intent is so that more of these become available. My worry is that actually what happens is less of them become available. So that's my concern.
And to your point, I would assume obviously all the informal leases don't have a written lease to start with. Somebody says, how much are you going to charge me to sleep on the couch? It's not like they're going to do a background check at that point anyhow, it's because of a friend, and they already know their background before they do a formal check. Councilmember Reamer.
Yeah, it seems like this is a very small share of the housing market. If I understand it, the kinds of places where we will place someone, those may well be group homes that are controlled by a nonprofit, versus just there's a house that's for rent with every bedroom rented out separately. That is, I think, I would imagine not very common for the government to have a relationship with such a landlord, but a group home is very different, and we should have relationships with group homes, and we do, and we can place people in those settings. So I just don't think that there's a lot of places that this restriction, I don't think it's worth. Anyway, I don't support adding it. I don't think it applies very much anyway. That's my interpretation.
Thank you, Councilmember Friedson. And then I understand that Courtney Hall from Interfaith Works is also on the call, and we'll call on him right after Councilmember Friedson.
Great. Well, I'd be interested in hearing what.
Okay, then let me
and then I'll go after if that's okay. Yeah. Since I evolved, from my last thought process when Ms. Sinclair Smith spoke, I don't know that I'm going to involve on this because I already feel pretty strongly. But but I'd like to hear Mr. Hall first.
And we will do that. Mr. Hall, if you'll please speak. And Ms. Sinclair Smith, let me just say, whenever I try to change Councilmember Friedson's opinion, I'll be calling on you.
Okay.
Anyhow, Mr. Hall, please.
Thanks for the invitation to speak. I'd just also like to support the position on this third amendment. We really do think that this could be very harmful and essentially could end up gutting the purpose of the amendment. I've had the privilege of following the discussion on YouTube, and I do think that the idea of sort of circling back to the purpose of the Housing Justice Act is really important. To think that if we're really serious about removing barriers to accessing affordable housing, then that really is the sort of the position that we should stick with. So many of these amendments, unfortunately, are removing some of the protections. And while it is clear that there may be sort of the letter of the law, I think we all understand that the way that the law will be interpreted and in fact implemented will continue to have disproportionate effects, especially on the people who are experiencing homelessness. In Montgomery County, we know those are virtually all Black and brown folks. So I would really encourage you to think of these amendments in that way, think of the potential disproportionate impact. And while we certainly wouldn't want to ascribe any sort of negative, we wouldn't want to have a negative view of any landlords. And I'm certainly not saying all landlords are bad, but people find loopholes. And that, I think, in many ways is what we're trying to close here. Let's close the loopholes and make sure that people can exit shelter in a timely manner into affordable housing solutions, because Montgomery County is very, very expensive.
Thank you very much. Councilmember Friedson.
Thank you. Well, first of all, my opinion wasn't changed because I agreed with what Mr. Hall said prior to going into it, which was my sense from the beginning. I think the bill as introduced, separating out somebody who is owner occupied, an ADU, or if you're renting out your space, I was concerned that would prevent somebody from being willing to rent out that space, and it would actually reduce housing. And as one of the co-sponsors mentions, Councilmember Glass mentioned, you get to pick your roommate or whether or not you choose to take on a roommate. And I want to encourage that in the county. We should be, as much as possible, because, we all know how limited our housing stock is and would hate to do that. On the broader question of a landlord determining who everybody else's roommate is, I think that's a little bit different, and I think there's a big difference between those two dynamics, and I don't think that there's as much of a risk of somebody who lives in a home that has an ADU or chooses to build an ADU and rent it out as an alternative stream of income, is not much of a problem. So I think the bill is introduced. I don't think there's a need for an amendment here. Makes sense. I just wanted to point out one thing. We've used group home and shared rental spaces interchangeably. They are not the same thing. A group home is a place where multiple people live, where services are provided. There's lots of reasons and lots of types of services. There's lots of types of group homes, but that is different than a shared living space where multiple rooms are rented out to different people. If there is not a unified, the group is the group setting to provide services to all of the residents in that place. Now, there's certainly a lot of overlap here because plenty of the folks that we are talking about require services, and some of them may be going to group homes, but largely what I am thinking about here, and I think what the big question here is the shared rental that is not a group home, that, whether or not and how, a landlord could choose and what they can consider and how and when in order to rent those spaces out. That is not a group home. I just want to make sure, for each of us as we talk about this, and for those who are following, those are two separate things. And, the group home setting is a place where services are provided. What we're really talking about here is just housing where services aren't being provided, at least not connected directly to the housing. And certainly, I think it's a very small number of the total housing stock has been noted. But as we've heard from the actual clinicians and those who understand this world better than I do, and I think most of us do, it is a disproportionate number of those who are finding housing and being rehoused. And, for that reason, I think that the bill struck the right, dynamic here. And I don't think that we should be or need to amend it further. Thanks.
Ms. Harris, did you want to comment?
Yeah, just quickly, I think Councilmember Friedson spoke to what I was going to say, just to clarify the difference between the group home and the shared living. And I will say that most of the folks that we're housing are going into private shared rental housing, not a group home operated by a nonprofit. I think it's also important to remember that most of the people that we serve in the homeless continuum do not have significant ongoing case management needs. That's about 25% of the folks we serve, but most people have fallen on hard times and they simply don't make enough to be able to afford rent. So that's all I wanted to say. Thank you.
At this point, I see no other comments, and there's no motion for this exemption.
I think Council Vice President Albornoz might.
Did you, Councilmember?
Yeah,
Albornoz?
and I'd like to make a quick point too after, but I'm happy to defer to the Vice President.
All right, very good. I can see Councilmember Albornoz, and now I get to speak on text. Please, Vice President Albornoz, please.
Yeah, I think that this has been immensely helpful, getting everyone's testimony, particularly on this amendment. And I agree that I don't think there is a need. I think we're trying to solve a problem that may not be big enough, or it may exist, but it's certainly not big enough in size and scope, I think, to rise to a level of a potential necessary amendment. And as is always the case with legislation, there's an evaluation process, and if there's ever a time we got to come back to, and there are unintended consequences with anything we do every time, there's always a chance to revisit it. But clearly the intent here is to open the door, as we all agree, to as many people as reasonably as possible here. So I concur with you on this, Mr. Chairman, that there isn't the need for this particular amendment on this issue.
Very good. Councilmember Jawando.
I agree with Vice President Albornoz. So it made it easy for what I was going to say. So and previous colleagues. So thank you all.
Thank you. All right. So we now have, if someone would like to make a motion on Bill 4920 as a recommendation to the full council.
So moved.
Councilmember Jawando made the move, and who seconded it?
Second.
Council President Hucker. All those in favor, please raise your hand.
Aye.
And aye, and that carries unanimously. +1, because I have a feeling Councilmember Glass would also is smiling.
Hey, that was quick.
Yeah, it was quick. Yeah, can you tell me what the lottery is going to be for tonight? Because you're just a guy that seems to be able to predict stuff. Yeah.
And 13 minutes to spare for those who need to be out by 3:30.
We're early. Thank you all very, very much. As my colleagues know, and as many people know, we will be together again this evening, starting at 7 o'clock for the public hearing on the budget.